Hi, everyone. I'm Lynda Chung. I'm a probate litigator at Valensi Rose. Welcome. This is a special coronavirus edition of the Beverly Hills Bar Association's Trusted Estate Program. Just a housekeeping issue. You'll get the materials and certificates by email, and you'll get a recording within 48 hours. And after the program, don't rush out of the meeting. Tell us how you did in the survey so that I can and Beverly Hills can improve our programs in the future. And I'd like to thank Sanborn team. We wish to thank Sanborn team for sponsoring the Beverly Hills Bar Association's Trust and Estate section since 2006. Servicing clients for over 35 years, the Sanborn team gives members and colleagues attractive results and peace of mind with a depth of knowledge of probate, trust, and conservatorship unparalleled in the industry. The Sanborn team's ongoing sponsorship demonstrates a tangible commitment to the probate and trust community and the Beverly Hills Bar Association. They are ready to handle any and all sales of a real property in Southern California. Think of them as the first resource for your real estate needs. All right, so let's talk about handling decedent estates and trusts with the community property or debt issues. And you will see the palm tree and say, hey, Lynda, why do you have a palm tree? It's because this program went through some evolutions. It started out as a probate litigation for civil litigators. Then it morphed into post-mortem debt collection. A while ago, a couple of months ago, I gave a presentation to National Trust and Banking Company, a bank, National Bank, and in front of their trust advisors and trust fiduciary officers. And the topic was California community property law that we often encounter in trust and estate business. So that's what the palm tree stands for. I put my contact information. I'm not very technologically savvy, so if you use the chat room or send me a text while I'm talking, I wouldn't be able to read because I'm just a clod electronically. So send me an email if you have a question, or if you like my presentation, and if you want to buy me a drink or lunch, send me an email too. Just quickly about me. I was born and raised in Korea and came here to get a PhD in anthropology at UCSB, but after I got my master's, I moved to LA and worked a little bit and then went to law school. And my master thesis in anthropology was a peasant migration. So how did I end up taking care of the top 1% in Beverly Hills? You'll have to buy me a drink to get the story. All right, here is a happy vegetarian guy, Leo Tolstoy. And I remember when I read the Anna Karenina, I think I read the Korean translation when I was in college, and I vaguely remember. And the other day, a couple of days ago, I suddenly thought about his first sentence, which was, all happy families are alike. Each family is unhappy in its own way. And I remembered it, and since I read it in Korean, I wasn't sure if that was a correct understanding. So of course I Googled, and it looks like it was properly translated. So is each unhappy family so unique? Are we dealing with the 50 shades of unhappiness? Fortunately, in Southern California, most probate litigation problems can be classified into one of the 4 categories. The first category is a capacity undue influence litigation, commonly known as will contests, trust contests, and usually it's one sibling suing the other sibling. When the other sibling, whoever moves in last before the parent's death, often gets the most. And either sibling is suing the other sibling, or suing the stepmother, or the caregiver, or the pool boy, whoever that might be. And most people think of a trust litigation as this first type of a will contest. And second one is just unhappy beneficiary suing the professional fiduciary, or it could be family member fiduciary, because the fiduciary is not giving them an accounting, fiduciary is not telling them anything, fiduciary is doing whatever he wants to do. I'm sorry for using he. It's just there are sometimes bad female trustees, but a lot of times I run into more male fiduciary. But I'm if I use he or she, I apologize. I may not be politically correct sometimes. Third category and fourth category. These are 2 categories we will discuss. Third category, I call it loosely post-mortem divorce, but obviously there is no husband or wife who is going through divorce once one of them dies. But why do I call it a post-mortem divorce? I have a good friend, a family lawyer. She calls a marriage an inventory. I know it sounds bad, but when one spouse dies, suddenly the divorce ends, and then what are you left with? You are left with the decedent's estate. Estate simply means assets and liabilities. Hopefully, you are dealing with a positive cash flow estate rather than negative cash flow estate. But sometimes you're stuck with the decedent who had more debts than assets. Then you got to clean up the mess. And that is the fourth category. Sometimes I deal with the third-party lenders who are not emotionally involved. They don't have any problems, no marriage disputes. They are just simply trying to collect money that the decedent incurred. So those are the 2 categories we'll be dealing with. How do you handle an estate, trust estate or probate estate that has community property or debt issues? Widow or widower, sometimes they are looking to the decedent's estate, and I'm talking about the widow, the grieving widow or widow, not third-party lender, who is still trying to recover his or her half interest in the community property portion of the estate. And sometimes it's purely hard, cold cash third-party creditor who is looking to the decedent's estate, and sometimes even the surviving spouse for collection. So people like me who came to California and never lived in another state, only in California, we sometimes think of a community property law as the universal law, but it's not. It's a heritage from the Guadalupe Hidalgo treaties. And then you'll say, Lynda, why did you put a yellow ink on Wisconsin? It's not a mistake. Wisconsin legislature, out of the blue, I don't know, I didn't read the history, it's too much information. They adopted the community property law, they legislated, so now they have, it's the one Midwest state that has community property law. Oh, and in Alaska, it's optional. You can choose whether or not you want to use community property law in your own marriage. So what is a community property? And because this is such an important aspect of a trust administration and probate code actually defines it. The term is defined as a property acquired during marriage by a person while domiciled in this state. And probate code section 100 provides what happens to the community property when you die. Once a spouse dies, one half goes to the decedent's estate, and the surviving spouse gets the other half. What if you don't want to split 50-50? Well, it's a free country. You can make whatever agreement you want to enter into with your spouse, but make sure it has to be in writing. Otherwise, you'll be facing a lot of litigation. And probate code section 104 provides what happens to the community property held in revocable trust. You'll say, Lynda, most of our clients are very affluent. They're not dumb enough to hold their assets in their individual name. They hire very smart estate planning attorneys, and all of their assets are in revocable trust. So what happens to the community property held in revocable trust? It is governed by the terms of the trust. Now, some of you who would like to question will say, wait a minute, Lynda, what if the trust created by one spouse does not sync with what the surviving spouse thinks as his or her property? What if, the surviving spouse's perception and the decedent's estate planning documents do not harmonize? Well, welcome to my world. That's where the trust litigators can solve the problem. And obviously you need to pay their fees, but we can solve the problems. So let's say one spouse dies, and he didn't just die clean, he left some debts. So what are the assets available to the creditors? The debtor's separate property is available to the creditor. The spouse separate, when I say spouse, I'm talking about surviving spouse. Her separate property is not liable. In other words, if my husband suddenly dies and leave a big debt, my separate property that I will get from my parents, my inheritance, and if I'm not the debtor, I'm not liable to the creditor. But here, there are exceptions, of course. Spouse may be liable for necessaries of life to the debtor. And this term necessaries, we don't hear that very often, but the family code sections use the term necessaries. I think it means necessities, but they use the term necessaries. Now, the debtor was a little bit clever. The debtor, before he died, he held the property with a totally unrelated person, a third party, and he holds the assets in joint tenancy with a third party. Let's say, nephew Johnny. Once the uncle dies, once the debtor dies, by operation of law, the joint tenancy property goes automatically to Johnny, the nephew. And this is a device that is very commonly used by debtors for asset protection, especially when the debtor is older and knows he's gonna die. But there is an exception, of course. There's a case called the Valensi v. Hope. And this case said that the joint tenant who received the property is liable. And you're like, why? The other tenant is not, he's not the debtor. Well, it's because there is a specific statute at issue in this particular case, and it was the Medicare statute. So the government get to collect money from the nephew who holds the property in joint tenancy. But if it is not, if there is no medical involved, the innocent third party gets the property. Now, whether the third party who got the property, joint tenant property, is innocent or not, that's a litigation topic. And often the debtors sue the innocent or not so innocent parties under the Voidable Transfer Act or Fraudulent Conveyance Act, and litigation goes on. Now, community property is generally liable for the debtor's debt incurred before or during the marriage, with certain exceptions. And that's Family Code Section 910. And after the death, the community property of the debtor and the surviving spouse is liable for debt of each other. And then I cite a case, Doe versus Rich. This is an interesting case because in this case, the creditor was not going after surviving spouse for the decedent's debt. Rather, in this case, the creditor was going after decedent's estate for the debt incurred by the surviving spouse, the live person. So it can go either way. If the debtor and the creditor hold the joint tenancy with the right of if they hold the property in joint tenancy, there is no specific case law, but with the right of a survivorship, of course, the creditor can go after the right of a survivorship property. That's what we think. Marriage. How do you terminate a marriage if you're not happily married? There are two ways to do it. One is divorce, which you can control when you do it. Death of a spouse, that is not controllable. I mean, not that I know of. Once one spouse dies while the divorce is pending, the family court loses jurisdiction. If there was a judgment or order that has been already entered by the family court, the family court would have a continuing jurisdiction to enforce the prior judgment or orders. But if it is a dissolution that hasn't been resolved yet, there is no marriage that needs to be terminated because one spouse dies, marriage is terminated. What if the joint tenant feloniously or intentionally kills the other joint tenant? Then you don't get the right of survivorship. Same thing with like the movie Double Indemnity. One spouse kills the other spouse to get the life insurance benefit. Same consequences, no benefits. Okay, so let's forget about community property and asset issue. We have some family lawyers and civil litigators attending this program today. So I will just talk very, very briefly about a very basic probate procedure. Okay, so husband and wife, they are married, still married, and one spouse suddenly dies. So what do? You have to decide what to do. If the husband or the wife was smart enough to have a living trust, then you just follow the trust administration. What if they don't have a living trust? And the only assets they have is just a bank account, a joint bank account. Then that's easy. Then the assets go to the wife, and there's nothing you need to do. You know, it's just the one bank account. Let's say if there was no will, there was a will, but there is no trust, then you need to probate the will. What if there was a will, but the estate is really small, and you can have a very expedited, simple procedure. Then if the estate is less than $166,000, then there is a very simple expedited procedure, and you just need to file an affidavit for small estate, and you don't have to go through a lengthy probate procedure. Now, those of you who are not probate or estate planning attorneys, this term estate can be confusing to civil lawyers and family lawyers, because we trust and estate lawyers use the term estate, and the term estate sometimes means different things. What is in 706 estate is not same as what is in a probate estate. So what is in probate estate? It's the assets that is in decedent's name, not the assets in a revocable trust, because the assets in revocable trust, it gets administered. It doesn't need to be probated. What if your spouse held a property with the other people as a tenants in common, like his brothers and sisters? That fractional interest, whether it's 25% or 30%, that goes into probate estate. What is in 706 estate that needs to be reported to Uncle Sam? That asset includes both the individually named asset as well as a revocable trust. Why? Because the decedent had the control. He had the power of appointment. He could remand or revise or revoke the trust. So that goes into the decedent's 706 estate. And of course, right now, if you have less than $11 million in the decedent's estate, you don't need to worry about the estate taxes. Also, properties held with others in joint tenancy, that still is a part of a 706, that is not in probate estate. So I know this can be confusing for those of you who are not estate planners, but that's why you need to hire people like us. Now, community property with the right of survivorship, that because of the right of survivorship, you don't need the probate, but it still is a part of a 706 estate. How about a bank account, pay on death account? You don't need to probate because it goes automatically to the beneficiaries. How about 401k, IRA, all those pension plans, retirement accounts? That goes by the beneficiary designation form. I had a very sad case. I represented not the decedent. The decedent was a 70-year-old man. He was married 3 times. I represented the wife number 2. When this gentleman divorced the wife number 2, he married somebody, a professional street walker who was 17 or 18 years old. This 70-year-old man and his wife number 3, they had bad habits. They used the recreational drugs. And the husband died of drug overdose. And wife number 3, legally married, nothing wrong. She wanted the husband's pension plan. Actually, it was an IRA account. I represented wife number 2, who was the designee on the beneficiary. And it's a federal ERISA law. It's a federal law trumps. Whoever is on the beneficiary, it can be your ex-wife, she gets it. So make sure your client updates the beneficiary designation form. And that is not part of a probate estate. Let's talk about very simple probate. Think of like the Steve Carell character in 40-Year-Old Virgin movie. He does not own a house. He dies, no will, no trust, no children. He only has $50,000 in his bank account. And even though he looks so innocent and honest, let's say he had $100,000 debt owed to multiple creditors. If you don't remember anything after this program, the only statute, if you're going to remember, is Probate Code Section 366.2, which states that the creditor needs to file a creditor's claim within a year from the decedent's death. And now you will say, well, you know, my decedent doesn't send me a Christmas card every year. Lynda, how the heck you expect me to know when the decedent dies? Well, that's too bad. It's because it's a one-year statute. I didn't make the statute. And also, what does the creditor need to do? The creditor needs to file a form. It's a mandatory judicial counsel form called a creditor's claim. And that needs to be filed. And it's governed by, under the Probate Code Section 9000 SEC. And you may ask, all right, Lynda, now you told me what the form looks like, but where do I file it? You need to file it with the probate court, and you need the case number. So and there is no one who filed a probate petition. So what do? You know, the sister of this guy, Steve Carell guy, she didn't want to file a probate petition because she knew there were about ton of creditors going after him, and there's only $50,000 in his bank account. Well, welcome to my world. The creditor, unfortunately, needs to file a probate petition and open the probate estate in order to file a creditor's claim, because you need a probate case number. It's a very unfortunate situation. And, you know, if you are a creditor and if you lend the money who are old or who are sick, you know, you have to accept the fact that sometimes some creditors die. And it comes as a surprise to a lot of creditors. And hey, it happens. Okay, so, you know, very simple probate estate. You know, there are multiple creditors who total 200,000. Bank account has only 50,000, and executor fees and filing fee, all that. There's expense. There's only $40,000 left, and the creditors get his or her pro rata share. But these are unsecured creditors. So if you are a secured creditor, you got nothing to worry about, because you have the collateral. You are the king, so you get paid first. What about the creditor who didn't get made in whole? What can the creditor do? Can the creditor go after surviving spouse? We will get to that. Next case, husband dies intestate, no will. He leaves some assets in his name. He has no estate planning. What does the wife get from husband's estate? This is an intestate succession question, and I don't need to explain a lot because the code is very specific. Read section 6401. Basically, if there is no children involved, the wife gets 100%, but if there is one child or one parent, wife gets 50%. I'm sorry, 100% if there is no issue, no parent. But 50% if there is one child or one parent, one grandchild from a deceased child, wife gets 50%. If there are more than one child, the wife gets 1/3. The other heirs get to split 2/3. Now, let's talk about the husband's separate property. what if the husband is still married, but he does not like his wife? Have you ever seen a couple like that? I'm sure there are more than few friends or clients you know who does not like his wife, but he doesn't want to bother to divorce. If he has a separate property, it's a free country. He can do whatever he wants. He can will his separate property to any person he wants. Okay, now let's talk about the husband and wife and with a modest asset but very substantial debt. Let's say husband was a very famous class action personal injury lawyer who handles huge, big traumatic injury cases, like wrongful death cases. And it costs a lot to go after 12 insurance defense companies. This guy, this plaintiff's personal injury lawyer needs millions of dollars to recoup $100 million class action cases. And there are hard money lenders who lend money to these plaintiffs lawyers. You gotta see the interest rates. I mean, it's astronomical. Anyway, the husband who is faced with the 12 defendants who are well financed by the insurance carriers borrows money, like $500,000 from a hard money lender. They had a house, nice house, let's say in a condo in Beverly Hills, small condo, like $900,000. They held the house as a husband and wife as their community property with the right of survivorship. So wife does the right thing. All she has to do is just simply file an affidavit of husband's death, and she owns the house 100%. That's what right of survivorship does. Nothing to probate, right? So does that mean that she can sleep well at night? Now she owns the house 100%? Not so fast. Why? The $500,000 loan the husband borrowed is a community debt. So she is not scot-free. In this case, we told the wife to, I think I represented the hard money lender and asked the wife to, nicely, let's settle it. And the wife says, no, I don't own anything. And except for the house, you cannot touch my house. And what does the creditor need to do? He has to file the creditor's claim that I told you 5 minutes ago. And then you will say, Lynda, but there is no probate. The wife took the house without she skipped the whole probate procedure. Well, this is a sad case for the creditor. The creditor has to open a probate estate by filing a probate petition so that the creditor can file a creditor's claim. And those of you who are collection lawyers or has a claim against decedent and decedent spouse, there are multiple very procedural deadlines within the creditor's claim procedures. If you are thinking of a one statute of limitation when you want to sue the decedent estate, you're not worrying enough. You should be thinking about 3 or 4 different statute of limitations, when to file it, when to reject it. Once the executor rejects the claim, when to file a civil action. All these statute of limitations. It's like a mechanics lien statutes. While you're taking a nap, the statute can run out. So you can ask me, Lynda, if you I filed the creditor's claim, what do I do? Well, creditor's claim in probate proceeding is just taking a number. You haven't won or lost anything. You need to bring a civil action to collect the money against the the grieving widow. I'm so sorry. Poor lady, you know, she lost her husband. Now she gets sued. In what capacity are you suing the wife? Make sure, and civil litigators who are dealing with liable people don't worry about this, but in probate litigation, somebody's title is very important. So in this case, you need to sue the wife as an individual, because why? It's a community debt. She is personally liable. And wife as the executor of the decedent's estate. So you are suing the wife. In the caption of the civil complaint, you are suing her in two different capacities. Now, when you are dealing with the debtors who are old, you gotta really make sure that your creditor has plenty of equity to go about. In this case, they owned a decent condo. I think it was worth like $900,000, but there was a secured lender with about $500,000 mortgage. And unbeknownst to my New York hard money lender and me, who was not familiar with the exemption for older people, I forgot the age, who was I think they need to be 65 or 67, I forgot. The homestead exemption for these elderly people is a whopping $175,000. So if the condo was $800,000, you subtract $500,000 secured lender's claim, and then you pay the broker escrow fee and the legal fees and the $175,000 exemption. You are left with about $100,000, which you can split with the grieving widow and the creditors. So I just have to tell people, if you're gonna lend money to older people, make sure you have a lot of equity in debtors' assets. Now, let's look at the next case study. This is the case I just told you about, the grieving widow who got one condo and who got sued. This procedure, when you sue the wife in different capacities, this is a little different when you are dealing with live people. I put in the case statute just to compare between dead people and live spouse. 11601 Wilshire Associate v. Grabo. I think Mr. or Mrs. Grabo was a lawyer, and the law firm was a tenant in a, West LA, Westwood building. And the landlord, when the law firm couldn't pay the rent, they sued the spouse. This is just a demur question. This is not a community property debt question in this case, because the spouse who didn't sign the law firm's lease is still liable. Why? Because it's a community debt. But as a procedural matter, the creditor cannot sue the wife who is not on the lease. It's just a demur question. But then you will ask me, yeah, Lynda, but how do I, collect the assets if husband is keeping all his money in wife's name? This is an enforcing judgment question. You can do it. There are procedures. You can levy the wife's community income, which is a paycheck. You can levy her bank account. You can garnish her wages. There are all sorts of ways. So you don't have to harass the debtor's spouse by naming her, and the other side will file a demur on you. Next, what assets can debtors reach? Debtors can reach debtors' separate property, but not spouse separate property. Let's move on. We have a lot to cover, so let's move on. Now, you will say, Lynda, you're talking about all these people who are dumb enough to hold their assets in their individual names. My clients are sophisticated. They hold their assets in their trust. So what do I do? Well, as I said earlier, do you remember in 706, revocable trust estate is part of a decedent's estate? Well, it is in the estate that is available to the creditors. I sometimes run into very successful, educated people who seem to think that creating a revocable trust is just the be-all and end-all, and their children will never fight, their creditors can never go after their estate. They just think that life will be wonderful after they die, and their children and their wife have nothing to worry about. That is not the case. Revocable trust is your asset. It's not a separate legal entity. How about creditor's claim? You know, you will ask me, Lynda, debtor had all his assets in trust. There's nothing in individual name. Does the creditor still need to file a creditor's claim? Yes. Then you will ask me the same question. What if there is no probate estate? Then I give you the same answer. The creditor has to file for the probate petition in order to file a creditor's claim. And don't forget the 1-year statute of limitations. There are a couple of interesting cases called the 001 and 002. 00 was the trustee, and the settlor died. The settlor had obviously substantial assets in his living trust. Otherwise, I don't think that you would see two different pellet cases in the name of 00. Obviously, they were able to afford the two sets of pellet cases. After decedent died, the medical center, the medical provider, tried to recover its unsatisfied judgment against the decedent's debtor. And they did file a creditor's claim. I mean, obviously, it's a sophisticated medical provider, so they know how to collect their debt. So they did file creditor's claim against the decedent's estate. They did not file a separate creditor's claim against the doubler in his capacity as a trustee. You remember I told you that capacity is important in probate litigation. So they brought a claim against the doubler as the executor, but not as the trustee. And on that technicality, can the doubler trust not give any money to the creditors? No. So creditor only needs to file only one claim. You don't need to kill more trees by filing more claims against, separate claim against the trust. One creditor's claim is enough. 002. So now that doubler, the sophisticated trustee, lost, and then he is faced with this unsatisfied judgment. Now, the question is, put yourself in the trustee position. You have, let's say, a big chunk of money in the trustee estate. It's not in probate estate. But you know there are creditors out there trying to get their sticky hands on the trustee estate. Do you have a duty to preserve the trustee estate so that the money is available to the creditors? Or can you just administer your trust and divvy out the money to the beneficiaries? The answer is the personal representative has no duty to preserve the trust assets. Why? Who are the people that the fiduciary owes fiduciary duties? Those are beneficiaries, not some strange hard money lenders. The trustee owes nothing to the creditors. Okay, this is a famous case. For some reason, when I was new in trust litigation, I had this dumb belief that if you are married and if you spend your spouse assets, that is okay. I have no idea. I don't know whether it's a fisherman's wives' tales, or I don't know where I got that. But this is a good case because I know some trust litigators don't like this case, but younger woman, I mean, you've heard of this story. Older man marries a younger wife. The wife goes on a wild shopping spree, spends a lot of money by charging on credit cards. Husband dies. Husband had grown-up children from his first marriage, and the husband's older son is the trustee, and he goes after wife number 2. So, I mean, the wife spent the money when the husband was married to her. The wife was not some caregiver that you can sue. So how do you do that? Well, under Family Code Section 751B, the wife owes a highest good faith and fair dealing to the husband. Just because you're married to a rich old man doesn't mean you can go out to Neiman Marcus every day and buy some fancy stuff. In this case, the husband's a successor in interest. He can bring a claim, and the code is 1101. And this is the second most important statute. Remember this code section, Family Code Section 1101. Why? I'll explain a little later in the next slide. Here is a man who was very successful. He was a sports car driver. He owned many cars that he designed. A big automobile company had a licensing agreement because there are cars named after him. He's a successor trustee, gives a notice to heirs. The wife gets notice. 120 days go by. And now you think, okay, and by the way, the trust was only prepared by the husband, and wife was not in the picture. You think that, okay, maybe I can start divvying out the money. And then the wife number starts making noise. She claims that the assets in his name, she has a community property interest. And you're like scratching your head and you're wondering, yeah, but you didn't contest the living trust within 120 days. So the statute of limitation is gone. Hello, what am I missing here? Well, a lot of family lawyers and some trust lawyers are not aware of a Family Code Section 1101 that gives almost unlimited statute of limitations. If you believe that you have an interest, community property interest in your spouse's estate, you don't have to bring it as soon as you find out. If there is a reason why you cannot bring it, let's say your husband is abusive, he owns a gun, if you want to assert your claim, you're afraid that he's gonna hit you for whatever the reason. If you have a reason you cannot bring a claim right away, then you do need to, you are entitled to wait, but you have to bring a claim, your spousal claim, upon the death of the decedent. So here, the wife missed the 120-day statute of limitations to challenge, and the statute 1101 does not tell you exactly what upon the death means. Does it mean 1 week or 2 weeks or 122 days? It doesn't define. So it's all factual question, giving more opportunities to litigators. But if you're representing a spouse who was shortchanged by the decedent, you want to file a claim ASAP. So then you will ask me, Lynda, okay, I can read the statute, but it's your job to tell me, how do I bring the claim? Don't just read me the community property statute. Well, there are many ways to scan the cat, and you can file a spousal property petition on the probate code section 13650. You can bring a civil action, or you can bring an A50 petition. When can you do that? I suggest that you do it ASAP after the decedent dies. Next question, do you need to file a creditor's claim? I read somewhere that you don't need to do that, but I don't remember where I read it. It could have been the Rudder Group binder, or it could have been a CEB series. So do your own research. I don't remember the answer. Now, this is a very classic post-mortem divorce. Husband was legally married to wife number 2, but they were separated, and the divorce was pending. But husband died. Husband actually knew he was gonna die. He had cancer, but he didn't finalize the divorce. Why? If he finalized the divorce, the wife number 2 doesn't get his very, very nice, handsome pension. As long as she's legally a widow, she gets his pension until she dies. It's a very, very nice pension plan. And this is not relevant to the material, but the wife was also retired government employee who had also her own pension. So when her husband died while divorce was pending, as I told you earlier, the family court loses jurisdiction because there's no marriage to terminate. The wife ended up getting, like, I forgot, like $120,000 from her own pension plan and $180,000 from husband's pension plan. So she's collecting like $300,000, and she's like 80 years old. Like, where do I sign up for a gig like that? It's a nice situation, you think, but wife was not happy. She filed a creditor's claim, and she claimed that the husband diluted or misappropriated the community funds. What did he do? He didn't have a mistress. Well, he paid, one of his sons went to like Harvard Law School. He paid the tuition. And he had the other son who was not as successful as the Harvard Law School graduate. His second son went to a drug rehab instead of Harvard Law School. He paid for the drug rehab while he was still legally married to wife number 2. So, I mean, yeah, I mean, it's ugly, but legally speaking, well, half of the money husband spent for his adult children, they were all grown-ups, not child support issue. You know, she can recover one half of the community fund that was used for husband's gift to his children from his first marriage. Now, this is a case where creditor sues after wife is divorced from the husband. Let's say husband incurs some debt, but before the divorce, but they got divorced, and the divorce stipulated judgment says husband gets house A, wife gets house B. You know, it spells out his column, her column, and our column. Now, some nasty collection agency creditor sues wife, even though she's divorced. She's like, what do you want from me? You know, I divorced my husband. I'm done. You know, done. Leave me alone. what is the wife's defense? Wives, and here is a third important statute. If you're a family lawyer, I noticed that a lot of family lawyers are not aware of Section 916 and the case called in re marriage of Brandon. In old days, actually for 100 years in California jurisprudence, if the wife gets community property, to the extent that she receives community property, she was exposed to the community debt that incurred during marriage. Now, Brander case explains that Family Code Section 916, I don't remember when Section 916 was legislated. It's pretty recent. I forgot whether it's 1985 or 1995. The common law was there for 100 years, but it's a legislation that changed the common law. So what's the law? Only if the debt is assigned to the spouse after the divorce, the spouse to whom the debt was assigned is liable. So if you're handling a divorce and if you are drafting a judgment, and if you are representing a more responsible spouse, make sure that the debt assigned to the more spendthrift husband is as broad as possible. Let's say the husband was in the business of collecting or refurbishing fancy cars like Ferraris or Porsche. But he ran a business in the name of, let's say, Newport Beach Fancy Motors, or, Newport Beach King or Tiger King, whatever. In the judgment, you don't want to just say that Newport Fancy exotic car debt will be husband's debt. You want to make sure that any and all debts related, arising out of husband's car business, including but not limited to Newport Beach fancy or exotic car collection, whatever, so that when the creditor sues wife, hopefully you can file a demur or motion for judgment in the pleading and use the divorce decree and do a request for judicial notice and say, hey, creditor, read my judgment and get off my back. This is a more recent case. Husband and wife, both of their second marriage. Wife had a house in Goleta. This is a Santa Barbara County case. Wife Hanako had one house in Goleta, which she used as a rental house. She created a separate property house in the separate property trust she created. She paid the $600 to the estate planning attorney to create a very simple trust that just has a Goleta. So what is the problem? After Hanako, the wife, died, her sons, it seemed like, got a little greedy. They wanted to interpret the pourable will. I don't even know why she had a pourable will. She could have simply assigned the house to the trust, but she had a pourable will that said, I give the residue of my estate. Again, remember the term estate? It creates a lot of problems and confusions. You only had the one house. Don't call it an estate. But here, she called it the estate. And the sons wanted to interpret the term estate, meaning her half interest in the community estate. And the Court of Appeals said, no. She wanted to keep separate properties separate. She didn't want to commingle it. So, oh, wow, it's almost 1:30. And I am very pleased that I am on my last slide. How do you minimize this type of unhappy situation? where the grieving widows or widowers have to deal with the creditors, sibling rivalry, and sort the assets and put the assets in his column, her column, and our column. Well, you need to have a difficult conversation before one dies. And people have different concerns. A lot of our clients do not have like serious debts. They are not concerned about asset protection. They don't have a reason to hide their assets. But what they are concerned are their adult children's marriage. There is no guarantee that your children will stay married forever. So they want to make sure that their children's separate property interest stays separate. And on top of that, you have to make end of life decisions too. And make sure that you sync your estate planning documents with your understanding or title of community property and separate property. After you reach an agreement, document. And after that, you will stay happily married. No, there's no guarantee, but you can try. And thank you so much. And I will finish the program. And if you have a question, please send me an email. Thank you very much. Bye-bye.